The
Welcome.
broadcast is now starting. All attendees are in listen-only
Welcome, everybody.
mode.
Sorry, I'm just doing some housekeeping there. Welcome to the January 2018 HR Best Practices webinar series. My name is Kevin Mosher. I'm a MSBA Certified Labor and Employment Law Specialist, partner up at Thompson Co. up in the Minnesota office. And for those of you who routinely come, thank you for coming. And then for those of you who are new, welcome to the webinar series. The webinar is approved for various CLE, HRCI, SHRM credits. And so if you've marked with your registration that you needed those credits, you'll get your certificate emailed out to you after the presentation. This month, also, if you have any questions, I see people have already started emailing, sending in questions, and that's fine. If you have any questions during the webinar, you're welcome to type them in. On the right side, there should be a little question box, and I'll try to get to them during the presentation. I should be able to get to most of them. I think we'll have some time here. And so anyway, so for the next hour, what we are going to talk about, normally in January, every year that we've been doing this HR Best Practices series, we've focused on, what happened the previous year, and then what are we prognosticating for the next year? Well, we're going to do that next month. The whole harassment in the workplace, metoo, there's how could we not be talking about this topic as soon as possible? And our webinar list had already been, schedule had already been filled out well in advance for November and December, so we couldn't talk about it then. But January, slot came open. We have to talk about this. Since in the last 4 months, this has become, one of the major conversation pieces around, not just in the United States, but around the world. But let's focus on the United States and particularly the workplace, and how it impacts, how this Me Too campaign, and then the Time's Up campaign, which is, now all of 2 weeks old, how this is really going to impact HR, and what is new, what's not new, what do employers need to be doing. And so let's talk about it. That's the plan for today. Okay, there we go. Okay. So for those of you who aren't familiar with Time's Up, the Me Too thing, I think most people have heard and understood that at this point. But the Me Too. So where did Me Too come from? Well, Me Too came as a response to probably the Harvey Weinstein allegations and stories, and all the crazy, weird, inappropriate, you name it, stuff with him. And so he was a really big figure there, and of course it had a direct impact on Hollywood. And whenever something has a direct impact on Hollywood, it tends to blow up into like a huge proportion. So the Harvey Weinstein was there. We also had Bill O'Reilly at Fox News, and probably half of the other Fox News newscasters and executives being accused and kicked out for sexual harassment in the workplace. And so the Me Too thing, and there have been a lot, right? There's Louis C.K. and there's Al Franken here in Minnesota. So it's way beyond Hollywood now. It's into politics, and it's also going to, if it hasn't already, it's going to just continue to permeate down to the workplace level. And that's what, that's why we're here to talk about that. So the Me Too campaign came as a hashtag, people jumping on and say, Me Too, I've also experienced sexual abuse, sexually inappropriate behavior, me too. So there's the hashtag for that. And that started, I want to say, in October. Time's Up is a newer thing that started as of January 1 in 2018. So there was an article in the New York Times about this, and there's been a fund that's been created since then. And I think Time's Up, although Me Too is like the more popular popular one that everybody's kind of known about. The Time's Up one has the bigger that what they're trying to do with Time's Up, which is to create a fund with I think $13 million that will literally be for supporting lower wage workers to make to get legal support to make claims of harassment against their supervisors and others in the workplace. So and then there are other aspects of Time's Up, legislative advocacy to change workplace laws. So for employers, when you hear Time's Up, that's the one that I think long term, that's the one that's really got the workplace in the crosshairs for the movement here, or if it's two movements, however you want to put it. But the conversation that we're having around harassment, sexual harassment, the Time's Up one is looking to take serious action to change the laws, to empower people to make claims against supervisors and coworkers in the workplace, and to, if necessary, bring lawsuits against companies. So Time's Up is what we, it's only like about 17, 18 days old, but that's the one that long term they're hoping, advocates would be hoping to have a greater impact. And if it does take off and continues like it is, it's the one that's likely to have a greater impact on the workplace. And, that we're going to have to be dealing with it, which is ultimately what we care about on this webinar series. We're going to talk about some harassment 101, just a general thing. We're going to talk about sexual harassment. That's kind of primarily, especially when we're talking Me Too and Time's Up, we're specifically talking about sexual harassment, but the laws go beyond sexual harassment, right? I mean, the laws cover harassment on any sort of protected class. And you might be in a state that has more protected classes than the federal law, Minnesota, California, a lot of states, Illinois, a lot of states have human rights acts or civil rights acts that have protected classes way beyond, the typical stuff that we see at the federal level of age and gender and race and religion. Minnesota's got sexual orientation, discrimination, prohibition. So we would want to worry about that sexual orientation harassment. But for the most part, we're going to focus on sexual harassment in the workplace, and we're going to look at some comparisons. What exactly is sexual harassment, or what is harassment, what's not harassment, and then we'll talk about some policies, and we'll talk about investigations. In part, one of the themes that we want to focus on, because most people I think on this webinar are HR professionals, or at least dealing directly with HR on a daily basis in a advisory or leadership role. When we talk about harassment, it means something different for everybody. It's clearly defined by the law. I don't want to say clearly, but it is defined by the law, and we'll talk about the definition of it. But there's also, there's the street use of harassment. People think bullying is harassment. It's not. Bullying is something entirely different, but people often use harassment anytime they're being supervised. That's very common. People claim that they're being harassed when they're just being asked to do something by a boss. People claim harassment all the time, and sometimes they just don't know. Sometimes it's disingenuous, but the use of the word harassment by, let's just say, normal people, the normal vernacular in English, the use of harassment is much broader than the actual, what is actually harassment, whether it's under a company policy or it's under the law. So we want to kind of focus on those differences. Well, we've been doing harassment training and these sorts of webinars and seminars for a lot of years. And in HR people, harassment's been certainly one of those topics that there's a lot of training on. Ideally, employers would be doing training every year or every 2 years at a minimum. Some states like California require it. Most states don't, but there's some movement. I would expect that one of the things that's going to come out of the Me Too and Time's Up movement is going to be a lot more states are going to start mandating workplace sexual harassment training. I think that's coming. I think it's a good practice anyway. Certainly you should be doing it every 2 years at a minimum, but I think what's going to be coming down the pipeline, because a lot of legislators have been, shocking. Politicians are like everybody else or worse, but they're doing a lot of states and the federal government, Congress, is moving toward making mandatory sexual harassment training for themselves as legislators. And so, it's going to be one of those things where once they figure it out for themselves, they'll be like, well, if we're doing it, we might as well have everybody else in, corporate America doing this. Again, nothing new in California. They've been doing that for a long, long time. But most states, almost every other state, that's not the case. There's no mandate. And so, the other thing with sexual harassment is it's not new. I mean, this has been going on a long time. I mean, you can watch old Hollywood movies, whether they're accurate or not. I think there's just, there's a lot of understanding that there's a lot of sexual harassment, and let's just call it what it is normally, which is male aggressors and female subordinates in the workplace. And so there have been some studies, and there's just a lot more awareness out there right now. I don't think anybody's surprised about that. If you pick up the New York Times or any local newspaper, you're going to see something about sexual harassment at least several times a week in the newspaper in the last several months. So some new studies have been coming out, and they're all kind of over the board, but for the most part, they're fairly informative. That you can see, here's one that was done last fall. So 1 out of 3 women between 18 and 34 has been sexually harassed in the workplace. I've seen studies, other polls and studies that show that same percentage for pretty much all women. There was a study done by Forbes last fall. And one of the interesting things about that was that out of the women that say they were sexually harassed in the workplace, 94% of them said that they believed nothing was done against the accused. That's a really high percentage. Now, a lot of that is going to be like, it's not really sexual harassment, right? It's not really. So an investigation hopefully was done, and they just decided, like, the allegations, what you're saying is harassment isn't actually harassment. So, that 94%, why would there be something done to the accused? But a lot of it is also informative on how people see HR and HR's role in this, and whether HR actually has any is empowered at all to do anything. And I think this is reflective of how people view, especially, let's just say, women who are in this position of being sexually harassed, how a lot of women view the companies and the culture. And I think 94% is a lot, and you can take out a bunch of those people as just being misinformed, but that's still a whole lot of people that just have a general sense that HR and the company are not responsive to complaints. And I think that's a real problem. And I think that's going to be an increasing problem for companies as they look at cultural changes, and they look at recruiting, particularly women to work. I mean, most college grads are women now. So in a professional setting, you would expect that most businesses would be recruiting women. And I think that's a real problem culturally. If you have this sort of workplace culture, if you're not embracing and opening up to people coming forward to make complaints, and if you're not taking proactive steps. And again, 94% is just a whole lot. Again, a lot of those people might be misinformed, but that's most everybody feeling like the company, right or wrong, that the company and HR were not responsive. Okay. So harassment 101. When I just step back and I look at harassment in the workplace, I look at it and I say, okay, why do we have, so what do we have to do? For all employees, OSHA requires this, Title VII kind of requires this at a federal level, but all employers need to maintain a safe working environment. that's if you just think about it, it's like, oh yeah, I guess I need to right, as an employer, I need to maintain a safe working environment. It doesn't mean giving ergonomic chairs or anything like that. That's not required, but it does mean that you need to do everything within your power reasonably to make sure that the workplace is safe for people, and that includes from one another, from coworkers and from supervisors. And so that's harassment. Now, harassment, again, like I had mentioned before, it goes beyond just, when I talk about harassment, I talk about it from a legal standpoint, which is to say, if I'm being harassed, it's got to be because of a protected class, whether it's because of my age or my religion or my gender or my immigration status could be one. I mean, there's like 13 of them, right? And then there are a bunch at the state law. So that's what I mean by harassment. But what a lot of people mean by harassment is just like, the person yelled at me. The person looked at me funny. I didn't like the way, they were bugging me, basically. And again, that's why we do these investigations sometimes. But that's what typical harassment is. But when I say it, I mean, like, harassment literally is violating the terms, adversely impacting the terms or conditions of my employment, or creating a hostile work environment such that it's so bad that it impacts the terms and conditions of my employment, and it's because of my class. It's not because, I have the unfortunate situation of being a Packer fan, with my wife being a Vikings fan. I mean, that I felt harassed, street harassment last Sunday, when the Vikings were eventually won. So, but it's not like that's illegal. That's not a problem, because, being a football fan is not a protected class, but being a male is, I guess, technically a protected class, or, national origin would be a protected class if you're from a certain country. So we look at those protected classes, and we've got a whole list of them. So that's harassment, and there are several types of harassment. So there's quid pro quo, and I think people kind of understand that. And that tends to be from a supervisor. So if a supervisor or manager says, hey, that's how they always start, hey, right? Okay. So they say, hey, how about you do this for me? You fill in the blank. You do this for me of a sexual nature, and I will give you a promotion. So that's quid pro quo. It still happens. But that's a form of harassment. The person on the receiving end, and a lot of like the Harvey Weinstein, a lot of these that were seen in the media, a lot of these are, quid pro quo. Like, there have been a lot of allegations against powerful men in Hollywood and in the news and everything, where it's basically like, look, if you want this job, if you want this promotion, you will do this, sexually gratifying thing for me. And that's quid pro quo harassment. And I think people, for the most part, get that. That one's easy to see. It's easy to spot. And it's, it's the one that we've been seeing the most in the news recently. And one of the other things, just a little bit of an aside, one of the other themes from what we're all seeing in the news, with, like, again, the Bill O'Reillys and the Harvey Weinsteins and the, kind of like the Louis C.K.'s and stuff like that, beside the crazy stuff itself that they're doing, is that this is in the workplace. I mean, Bill O'Reilly stuff it's in the workplace. Harvey Weinstein, it's in the workplace. This is not necessarily just like, hey, I met you at a bar and, got a little touchy feely. It's not that sort of harassment. This is literally workplace harassment. And so one of the themes with all of these stories is how this abuse of power from these men is really, it's quintessential workplace, hostile work environment, quid pro quo harassment. And so, as these stories are coming out and everything, I would encourage you to just kind of look at them and see and note that a lot of this is workplace harassment, and a lot of these are putting the companies at in a real bind. I mean, but they're having to fight it in the media at the same time that they've got to actually do their own internal investigation to determine what to do. I mean, Harvey Weinstein helped found his company, and immediately once these things, or shortly after these things all came to light, it's like his company, the board of directors, had to start taking action to investigate this while he's being crucified, rightly so, in the media and online and social media and everything. But as a company, they still have a responsibility. And so who's paying the settlements? Well, it's probably the company, or maybe the insurance carrier, as well as on the hook. I mean, these are all lawsuits. Same with Fox News. I mean, Fox News is settling up, tens of millions of dollars in threatened lawsuits and lawsuits by former employees over there against Bill O'Reilly and all the other a lot of the other executives and stuff. And I mean, that's coming from probably insurance funds. It's coming from the company itself. It's not likely coming from the individuals. And so it's just another theme to watch as this national conversation plays out. And then the other, so jumping back in, then the other, beside quid pro quo harassment, we've also got harassment itself, which is, you can see the definition there, severe, pervasive, enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. And so that's the type of situation where you've got touching, but anyway, it creates a work environment which is similar to, it's a little bit different, but similar to hostile work environment as a form of harassment. And so hostile work environment, again, is the workplace is sufficiently intimidating, hostile, or offensive. But this definition is really critical. The whole severity and the pervasiveness. It's rarely, if you look at lawsuits nationally over the last 20, 30 years, rarely do you see courts find that just an innocuous touching or comment or one single joke told, it is very unlikely to create a hostile work environment. It's very unlikely to be harassment. Now, if that single joke is really, really offensive and somehow makes the person so fearful, yeah, I guess there's facts could always differ. But for the most part, we don't see lawsuits be legitimate against employers until you have touching, or you have a lot of conduct over a period of time, or a lot of jokes and pictures and non-touching but offensive, intimidating situations. It's when there's a real distinction between touching and not touching. But again, the severity and the pervasiveness is critical to this point to understand whether or not it could be harassment or hostile work environment. So, what is generally not harassment? Unlawful harassment. Again, if it's harassment, it could be street harassment, general, understood harassment, or it could be against your policy. So I am not saying that there's nothing for a company to do, but when I'm talking about the law itself, this is, the law is not going to say this is illegal, unlawful harassment that you're going to be on the hook for as a company. So petty slights, cold shoulders, that sort of thing, annoyances, and a lot of your harassment claims, a lot of your claims that come in, complaints from employees. I mean, not everybody's Harvey Weinstein, thankfully, right? A lot of the complaints that HR gets, they have nothing to do, they're not harassment. They're just petty slights, they're annoyances, they're being supervised, not liking your supervisor, not liking a coworker, but it's not harassment. It might not even be based on sex. But it could just be I'm complaining to HR. Doesn't mean HR shouldn't do anything about it. HR, generally tries to be, normally companies want HR to be responsive and be an ear to listen to. But it doesn't mean that there's going to be a lawsuit or that there's any real liability or exposure here to a big fine just because it's petty slight or annoyance. Isolated incidents, again, light brushing, touching of a shoulder, maybe a hug over, a 1 year. There are cases out there where supervisors have shown pornography to coworkers and even tried to kiss them, maybe did kiss them against their will. And if it's spread out over a period of time and the person kept working, it might not be a hostile work environment. I mean, one court might find it is, one court might find it's not. But if it's an isolated incident, I mean, if they were extremely serious, kissing is pretty serious, but it can get worse, and that would be different. But just like a hug, maybe an inappropriate joke a few months later. I mean, these are spread out over time. They probably wouldn't be unlawful harassment. Doesn't mean a company shouldn't do something about it, but legally, probably not unlawful harassment. The conduct creates a work environment that would not be intimidating and hostile. So if whatever the person did doesn't create an intimidating, hostile, or offensive work environment to a reasonable person, then it wouldn't be unlawful harassment. And if the employee didn't personally find it intimidating, hostile, or offensive. So if you're doing an investigation into allegations, these are the sorts of things that you want to be looking for. You want to find out, like you want to ask the types of questions. What is it about? Is it intimidating? Try to figure out, is it intimidating? Is it hostile? Is it offensive? And then this employee, this person who's complaining, did they personally find it intimidating? I mean, what's hostile to one person might not be hostile to another. And if it's not hostile to you personally, or intimidating or offensive, you've got a higher threshold for whatever that conduct is. If you didn't personally find it intimidating, hostile, or offensive, then it's not unlawful. Then there's no liability there for you and for the company. So again, as I'm doing an investigation, this is what I want to find out. I want to find out how they perceived it, and I want to find out what exactly happened to figure out if it objectively is hostile, offensive, or intimidating. Again, quid pro quo. This is the definition for quid pro quo. This is what we look at. And again, I think this one's pretty easy to figure out. It's why so much in the media, it's easy to write these stories about quid pro quo harassment. I think people just generally have a pretty good gut sense that this is pretty crappy and easy to spot. It's the more nuanced hostile work environment that is harder because of the subjectiveness of it. And again, it has to be unwelcome. It has to be unwelcome to the person. Some of the stories that you hear, they don't, at the time, they don't sound like they're unwelcome. So you have to kind of listen for that if you're reading stories, and if you're in HR and you're getting complaints, this is what you have to figure out. Yeah, okay, maybe now you find it unwelcome, but did you at the time? Was it unwelcome at the time, or was it consensual, stuff that was going on in the workplace? And what's consensual? One, you could have coworkers that are dating. A lot of coworkers date, and you could have coworkers that are dating, and then and you might want to do a love contract or something like that to just clear everything, to make sure that everybody understands harassment policy and all that. We call those love contracts. But if it at some point becomes unwelcome and somebody comes in HR says, we're breaking up, and I don't want it. This is awkward. I don't want the person, they continue to say things to me or even touch me. Well, yeah, then that's a problem. Then that line's drawn, and HR needs to step in and do something to save the company from any liability and to promote a good open door culture. Hostile work environment always involves person of a protected class. Again, you could come in and harass me all day long. I've been subjected to it as a Packer fan for many years here living in Minnesota. But does it give me any rights? No, absolutely not. It makes me feel morally superior, but it doesn't make me, it doesn't give me any legal rights, I guess, for what that's worth. A reasonable person needs to find it offensive. And that's always a tricky thing with the law. What's reasonable? It's this subjective element. So what is a reasonable person? So would a reasonable person find it intimidating or hostile that such and such is said? Well, if the answer is no, then then it's not illegal, unlawful harassment. And then it has to be severe or pervasive enough. Just a little comparison between unlawful harassment versus policy violations. So that's illegal, unlawful harassment. So when you get legal counsel involved and we're advising on things, we talk about unlawful harassment, like how are you going to get hit with a lawsuit, right? So, for example, there's, I would mention a case. There's a good case out there where a supervisor had shown pornography to this is years ago. It's probably a 15-year-old case. So had shown some pornography to on his computer to a coworker, subordinate, and then said, "Oh yeah, take a look at this." He's like watching pornography, okay, and then tried to kiss her several months later. And there might have been some other like little things here and there. I'm sure there were. So, but the court said, it's just spread out over time. It really wasn't unlawful harassment. Didn't create a hostile work environment. She continued to work there, and she just didn't seem overly affected. Now, this case is 15 years old. Would things be different today? They very well might. That case might be a loser for the company today. But 15 years ago, it was at least okay. And I think a lot of courts would find similar, like just these one or two situations that aren't overly bad, would probably not be illegal harassment or unlawful harassment. However, does that mean the company shouldn't fire him immediately upon an investigation that finds out this stuff? Absolutely not. I mean, very few companies that have sophisticated culture and management, very few companies would find that out, that a supervisor showed a coworker, a subordinate, pornography and or tried to kiss her. Very few companies are going to let that go and are not going to demote or maybe fire the supervisor who did that. Doesn't mean that they're going to get sued successfully, but it does. But most companies have a much lower threshold for what is inappropriate harassment in the workplace, and I think that's appropriate for most companies to have a much lower threshold. I know when I write employee handbooks and these sorts of like harassment and discrimination policies, normally I write the threshold as being much lower than what the law requires. And so yeah, I mean, if you're called in, you're going to do an investigation. So for example, we've got this list here. We've got, quid pro quo harassment, right? Or stalking, forced fondling, right? Touching, potentially unlawful harassment, sexual assault, absolutely. Objects of sexual nature, communication of a sexual nature. These are all things that could be unlawful harassment. They're absolutely going to be violations under your policy, or they definitely should be. But companies normally have, like I say, a lower threshold. So inappropriate looks, maybe, kind of depends. I mean, if it's daily, if it's making the person feel uncomfortable, yeah, you might want to go in, have at least a counseling session with the coworker or the supervisor who's giving inappropriate looks. Unwelcome flirting, absolutely. You're going to do something about that, or most companies should these days be doing something, let's put it that way, about that. You have a lower threshold, and mainly it's to save your own liability. It's to protect the company from these potential lawsuits. I mean, yeah, you might win in a lawsuit, but you're probably going to spend a ton of money defending yourself. So great victory, but you've spent a lot of money defending. You don't want to get there. So most companies should have and do have a lower threshold. It also is part of creating a culture that welcomes people and that tries to stamp out harassment, sexual harassment, especially in the workplace. So again, inappropriate jokes, yeah, it might not be a legal violation, but most sophisticated companies these days don't or shouldn't allow for inappropriate sex-based or race-based or whatever it is jokes in the workplace. So I've put together, I think it's 7 or 8 points, and so it's kind of a test, but I didn't really open it up for a quiz or anything, but let's just take a look at this, because I think there's just a lot of nuance with these. I mean, there is no bright line as to what is harassment and what's not harassment. And so I think, this comes to HR. This is what HR people get paid the big bucks to do, to look at this stuff and to really analyze it and make some qualitative decisions on it. So, okay, so let's talk about these. So is it unlawful harassment, or is it just risky behavior for the company? Could be both. So dropping something. So if I drop something and then I ask somebody else to bend down and pick it up, right? In and of itself, probably not unlawful harassment. Super creepy. Not something that a company, but not something that a company would want, coworkers or supervisors to be doing. Absolutely. It's potentially unlawful harassment if it happens a lot, if you find that it's pervasive, but it's could be even a form of quid pro quo harassment, but it's completely inappropriate. And might not have been inappropriate 100 years ago, but it's definitely inappropriate today to do that. So maybe unlawful harassment, definitely risky behavior to allow something like that, something that HR would want to address and stamp out if necessary. A coworker leaning in to smell somebody's perfume, again, creepy. Going to be the basis of a major lawsuit for hostile work environment, sexual harassment? Not likely. Add it to dozens of other things, maybe. Maybe that's a bad circumstance, but is it risky? Absolutely. HR should counsel the person on not doing that. This should be part of, the training that you give so that people don't make these, dumb decisions to invade somebody's space and, talk about perfume, which is kind of, related to the person and their sexuality and stuff like that. So not a good idea. You would want to stamp that out. Commenting on somebody's outfit could be okay. It might not be okay. Generally, just telling somebody that they look nice, it's fine. I don't even think that's necessarily even risky behavior. Telling somebody they like their dress, their pants, their, hat, whatever it is, I think it's going to be okay. Now, if you say it in a really weird, bad way, the way it's being said could be different. So that's why we always want to investigate these things if they come to our attention, and we want to, take the steps that are appropriate. But as a general rule, just, commenting, saying that somebody looks nice today is going to be okay. Commenting on somebody's figure, yeah, I mean, that's different, right? That's creepier and it's risky. So we would want to, at least counsel. Doesn't mean you should go and fire somebody for just doing that once, right? That seems a little extreme. Again, if it's part of a huge lot of things that the person's done, maybe it rises to termination. But for the most part, just commenting on somebody's figure, a one-off, you counsel them on it, maybe give them a written warning, something like that. But yeah, it's a little creepy. So I would, you would want, as HR, you would want to do something about it. Telling an inappropriate joke depends on what the joke is and how inappropriate it is. But yeah, for sure, that one is, you're going to want to do something about it. Sending inappropriate images or videos to coworkers. First of all, it's stupid. A lot of these, you just want to get rid of people because they're stupid, right? Maybe just fire them for being dumb. There are a lot of laws, a lot of situations where it's justified to fire employees for just being stupid. One of them is sending inappropriate images or videos to coworkers, and that's kind of a thing these days. So with Snapchat and all that, people are just getting inappropriate stuff from coworkers. That just happens. And so that could definitely be unlawful harassment. Again, one-offs, probably not, but it really depends on what the image is. I mean, if the image is of, nakedness or whatever, inappropriate body part is being shown, yeah, that could be pretty bad. And that could be beyond being a terminable offense, could be potentially unlawful harassment. Touching a coworker's shoulder, like a one-off, probably no. A policy violation, absolutely. Especially if, depending on the context of it. I mean, the more sexual the touch is, whether it's a shoulder or touching an employee on the hips, that's a common one as well. If you pat somebody on the back, that's probably not as bad as touching them on their shoulder or touching them on their hips, which is probably the worst beyond touching genitalia. So, inappropriate, potentially depending on the context, risky. Anytime you're touching somebody, it's going to be risky in the workplace. But it's something HR at least should address. Let's put it that way. Reaching up a coworker's skirt, absolutely. If it's not clear that that's inappropriate, we should probably do some more training. So yeah, that one definitely we don't have to worry about. Things that HR people need to watch out for. Obviously, you have to watch out for the supervisors. And the reason is, and not to scare you all, but supervisors are considered part of management technically. And supervisors and managers and all people up above, they're all agents of the company. And so what does that mean? That means that what they do then is going to impart liability onto the company itself. So if a supervisor does something, let's just say punches a coworker or a subordinate or touches somebody inappropriately, sexually harasses, whatever it is that's bad, that liability is going to go to the company. And so the company is going to be the one that's going to have to defend that lawsuit, if there's a lawsuit, settle it up, that sort of thing. That's why Harvey Weinstein and several of these other people that are in positions of power in Hollywood and Washington and all that. That's why their companies are coming in, and the insurance companies behind them are coming in to settle these claims. And they're the ones putting up the money and not the individuals themselves, because they are agents of the company. And so that's really why we do supervisor and management training on sexual harassment in the workplace, because they're your front line. They need to promote the culture that protects employees in the workplace and makes it a safe working environment. But you also need to make sure that they understand, like, whatever they do could really get you in big trouble as a company, and they are the ones that have the easiest way to create the liability. They're also the ones that, because power corrupts, and at any level, seemingly that people use that sort of power, whatever amount they have, to use it over others. And so that's a real problem for the company, and obviously for the culture and the employees that are subjected to that. Coworker harassment is more nuanced. So from a legal standpoint, companies are only liable for harassment from coworkers when the company knew or should have known about it. So that's why we do harassment reporting mechanisms in the policies. So if you don't have a harassment reporting mechanism that says, if you feel like you've been harassed or discriminated against, I always say discriminated as well, but specifically harassment, if you don't have a policy that says, if you've been harassed and discriminated against in the workplace, you need to come to this person, that person, and another person. And you want to have multiple people in the report. Like, do you come to HR? And then if HR is not responsive, you go to the COO. If the COO is not responsive, you go to the CEO. But you give multiple layers of people that employees can report to. And the reason you do that is because if you have that sort of policy, and if it's coworker harassment, and if the person who's being harassed never, didn't follow the policy and didn't bother to tell the company, then the company can defend itself in court and say, you know what, we didn't even know. And how could we have known that this one time, or a couple times this coworker had done this inappropriate action? How could we have known? We had no idea. No supervisor knew about it. No manager knew about it. HR wasn't told. Nobody no agent of the company, no supervisor and up in HR, nobody knew about it And therefore, then as a company, you can defend yourself. And your legal counsel can say, oh, we had no idea. How could we have stopped something that we didn't know about? You don't get that. You don't get to say that when it's a supervisor or a manager, because they're agents of the company. Like they get to do it. They're speaking on behalf of the company. If they're the harassers, then you're in pretty big trouble as a company. But for coworker harassment, that's why we have to have harassment policies that have reporting mechanisms, because then it gives us the chance to defend ourselves and say, we would have done something but for your not telling us. And we told you how you had to tell us. It's in the policy. You have to follow this reporting, and you didn't tell us. So how are we supposed to know? So that's why we have to, that's the good news, I guess, about coworker harassment. That's why we have to have those reporting mechanisms. And then here are the other points in the so there's like that shoulder touching, that seems, that's, as opposed to like a brush, like that one seems, again, it's all nuances, it's all circumstances, seems to be a little bit more sexual, right, than just like light. So again, you're gonna have to figure out if it's shoulder touching, have to figure out which one, how to address it, and it's based on the facts. And that's why we do investigations. So key points in the policies: reporting mechanism, that's the most critical part. You have to have an anti-harassment policy. If you don't in the handbook, then you have to do it, at least communicate it to all employees. You've got to be there. You want to have a statement about anti-retaliation. If you report harassment, it's open door. We have a culture of doing this, of allowing people to come forward. We will not retaliate against you. You want to have that in the policy. And again, it's one thing to have a policy, it's another to have a culture that empowers people to come forward and not fear. Most, if you poll most women, let's just say in the workplace that have experienced this, they're going to say that they were afraid to come forward, and that they felt like that they wouldn't be heard, or that HR wasn't an advocate for them, and that the company would protect the harasser. Whether that's right or wrong, it's a challenge for HR people and management to create a culture that combats that. And I think as we go forward, we're going to get more and more and more of these as metoo and this whole movement and conversation goes on. You're going to have more and more and more people in the workplace coming forward and feeling empowered to say something. And if they're not heard, and if HR is not responsive and management's not responsive, I think you're going to start seeing more and more and more lawsuits on this. And that's even if there's not a lot of liability, there's definitely a lot of bad press involved with this, and bad media. And it's not like you don't want the last thing you want is for your company to be the new hashtag, and to be the one that is going viral for a day or even a minute, and talking about your company and your culture and everything. So I think most companies these days should be having conversations internally about, it's one thing to say that they have an open door and that they have a reporting mechanism and that they don't retaliate. It's another to really live it and to really sell it and make employees understand that this is truly what we're about. So beyond that, one thing. So that's the be nice to employees soapbox speech that I rarely give. The other thing, so taking that soapbox away, so this is how we get to employees, right? So one thing that we could do is definitely in severance agreements. If there's any sort of risk and you're worried about it at all, you're settling up with any of these employees, or there's any sort of risk, definitely get a severance agreement. Don't just give them severance money. That's not good faith. Giving people money doesn't do any good. You need a legal document to get from them. So you need a severance agreement or a settlement agreement, and it has to waive all claims against the company. And then you also want to have non-disclosure language. A lot of these women coming forward now are breaking non-disclosure agreements. So again, it's just an agreement. I guess it could be costing them money and stuff like that. But you want a non-disclosure agreement to stop employees from, if they're taking money, settling out with a severance agreement or a settlement agreement, you want to stop them from disclosing it. So definitely having non-disclosure agreements in place is a good idea to stop them from going on social media and talking about your company. The other thing to look at is consider an arbitration requirement for all employees regarding harassment and other workplace claims. Now, for the most part, arbitration agreements like this have been upheld. There's a huge counter punch, movement right now to put a stop to these arbitration and agreements, because a lot of these claims that are from women that are coming forward, they're forced to arbitrate. Now, arbitration tends to be private; it's not in the public sphere. The media, it's hard for the media to get a hold of it. So this is it's private arbitration. So employers that are really concerned about harassment in the workplace may want to consider requiring all employees to sign employment agreements that require arbitration of harassment and other workplace claims. Because a lot of employers are using that to their advantage, and again, consider it. It's something definitely to consider these days. But because of that, several states are now looking at prohibiting these sorts of arbitration agreements. I think those states would have a hard time. I think, anyway, I don't want to bore you with legal analysis, but I think they'd be preempted by the Federal Arbitration Act. But anyway, states are looking at getting rid of arbitration agreements in the harassment context. So something to watch for in the future. Okay. Investigations, again, kind of an inappropriate shoulder touch. But all shoulder touches are not equal. I guess that's what I would say. So why are we going to do investigations? If we are trying to have a culture and increase morale, we want to make sure, the economic reason is it comes down to productivity. If we want to have a company that is productive and the employees are productive, we want to make it a safe working environment. We want employees not to be worried about their safety. And so part of that is to do investigations and is to root out and get rid of the people who are potential impediments to that safety. And so that's, your economic argument. Also, there's now morale and a cultural argument to be made that, you want to attract people that are going to work here. A lot more people are going to be women that are entering the workforce, and especially in a professional environment. And so you want to attract them to come and work for you. So it's a recruiting issue, and it's also a media issue, a perception in the public on what the company is about. So who should be doing the investigations? Generally, trained HR professionals, like many of you on the webinar here, generally trained HR professionals are good people to do these investigations. Outside attorneys, like me and other attorneys and HR and employment attorneys can also do this as well. But it should be somebody who's responsive and who can do a neutral investigation, because you want to give the reassurance to the person complaining that this just isn't some trumped up in-house investigation that's just going to shove whatever it is under the rug. You want to have a real legitimate investigation done, and sometimes an HR person can do it, but sometimes you have to go outside to do it as well. You want to do it also right away. So you don't want to delay it. The longer that you delay it, the more it seems like it's not being done in good faith. Generally, this is the investigation flow. You examine the allegations. You start with the person that's alleging the harassment. Get the whole story. Figure out the scope of the investigation. You don't have to do this for every petty complaint that comes in, but for the most part, you get the allegations. Have the person even sign off on them. So you kind of define the scope of what exactly they're complaining about, and then you determine the nature of the investigation as a sexual harassment. What exactly are we doing here? And then you look at, based on the nature, you look at the potential policies. So are we looking at the anti-discrimination policy? Are we looking at a bullying policy? Are we looking at a code of conduct policy? So you kind of look at those policies to figure out what are the guidelines going forward. And then you analyze. After you do the investigation, gather all the facts, and then you analyze them against the policies to see what happened. So we have, things that when you're looking at and you're assessing the allegations, these are the things you're going to look, these are the questions you want to ask yourself. Are there any inaccuracies? Was the person complicit? Were they part of the problem? How critical is the timing? What's the timing between all of this that's going on? How sensitive is this? Is this the type of situation where I need to suspend the person who's accused? That's one of the early considerations you want to have. Do I have to suspend? Do I have to get this person out of the workplace that's being accused? Because if I keep them in the workplace, they're going to impede the investigation, and then they also might do it again. Because again, we have to ensure a safe working environment. And if we have any suspicion that somebody who could hurt another employee is continuing to work in the workplace, that's huge liability for us if that person does hurt the accused or anybody else. Because we kind of know about it. And so we might need to suspend the person with or without pay pending the investigation. And then we gather facts. And these are the steps that you generally do. Get the initial story, identify the people from the story, and then interview them, get copies of documents, and then keep going back until your investigation's full and you feel like you've got a full story. And then you look at the policy, you figure out what your past practice is based on my findings. A lot of times it's he said, she said. You're going to make a determination. It might just be a judgment call. Like you believe one side more than another, and that's fine. HR, companies get to do that. They get to make that judgment call based on all the facts that they're getting in. But what's more important than the call itself, than the ultimate decision, what's most important is that you actually follow this process, and that you follow a process of investigation so that it is legitimate, not just appears legitimate, but is a legitimate process, and shows good faith, and that you as a company are trying to comply with the law and root out, you make it a safe workplace. Just some tips on interviewing, asking questions from multiple angles, just trying to get to if you're not used to interviewing and you're not used to doing these investigations, this is just some tips for you to do it. Having two people interview is perfect, but you don't have to. It could just be one person as well. But again, all these questions and all these ideas, this is all to get to your understanding of making the ultimate decision in probably a he said, she said. And then just some tips on other things not to do. You want to take it seriously. You want to give the person the appearance that you are taking this seriously, that this is a process, that you're being legitimate. And again, you are being judged as well as the HR, interviewer, as the counsel interviewing. You're being judged by the person who's accused. What you don't want to do is give them the idea that you're biased, that you're uninterested, that you're not really listening to them, because people who feel that HR is not being responsive, the company is generally not being responsive, then they might go and get an attorney. I've seen a bunch of things on various news outlets about people giving advice to employees, and the employees saying well, I brought this complaint, but HR is not going to do anything about it. And the responses are, don't even bother with HR, go straight to a lawyer. A lawyer is going to get you what you need done. And it's that's the last thing from a company we ever want to happen, right? We don't want lawyers on the employee side getting involved. We want as HR, we want these to be brought to our attention, but then it's HR's responsibility and the company's responsibility as legal counsel or management. It's that responsibility to actually then be actually responsive, and to give the employee, make them understand that we legitimately are being responsive. And then we just analyze the situation, maybe call legal counsel if you haven't engaged legal counsel at that time, to review any of the legal issues that are raised by the findings of the investigations. And we just analyze it, got the facts, we've got the policies, and we just look at it, and we come to a decision and engage legal counsel and see what our risk is on the situation, and then make the call. And then we give the response to the accused. The accused might not like it. We don't have to share with the accused what we're doing. If we're going to suspend or fire the accuser, we don't have to talk about that. But there are a lot of but it's common to tell the accused what you're doing, so that they don't get frustrated and go seek outside counsel. And then common responses to somebody who's being accused of sexual harassment is termination, reassignment, suspension, counseling, mediation, demotion. You can really do it whatever you want with them. So anyway, 1 hour exactly. It's 1 o'clock. I appreciate your time. If anybody has any questions, you're definitely welcome to reach out to me on my phone number. I think it's all on the website. Next month, we will be talking about what happened in 2017 with Trump and HR and all that, and we'll be looking at what we are looking at for 2018. And with legislation and changes in HR, because there's going to be a bunch of stuff coming down the pipeline. Thanks for your attendance, and feel free to reach out to me with any questions.